In my last video, I provided a do-it-yourself step-by-step for Florida's disposition of personal property without administration. It's Florida's simplest form of probate for very small estates. If you find that you don't qualify because the decedent's assets exceed the limits for the disposition of personal property without administration, then summary administration might be the next option. And while I don't generally recommend attempting summary administration without the guidance of a Florida licensed attorney, some of you may still want to try to go it on your own. So if you're trying to figure out how to handle a loved one's estate without going through full probate and you're hoping to do it yourself, you may be in luck. Florida offers a simplified probate option called summary administration, and in many cases it can be done without an attorney. In this video, I'll walk you through how to file for summary administration in Florida, when it's available, what forms you need, and common mistakes to avoid. Summary administration is a streamlined form of probate in Florida designed for smaller or older estates. It's faster and less expensive than formal administration and doesn't require the appointment of a personal representative in most cases. You can use summary administration if the total non-exempt value of the estate is $75,000 or less, or if the person has been dead for more than 2 years, even if the estate is worth more than $75,000. This process works whether or not there was a last will and testament, but the legal steps are different depending on whether the decedent died testate with a will or intestate without a will. Summary administration is not appropriate if there are ongoing disputes between the heirs or beneficiaries, the estate has significant debts that have not been addressed, or if the estate requires complex creditor administration. Before you file anything, you need to gather some basic information: a list of the decedent's probate assets and their estimated value, a certified copy of the death certificate, the original will if there is one, a list of heirs or beneficiaries and their addresses, and a certified copy of the deed or legal description for any Florida real estate is extraordinarily useful. Be sure to determine whether any assets are exempt, such as the decedent's homestead property or up to 2 of their vehicles. Exempt assets are not counted toward the $75,000 limit. You also need to identify any debts. If the person died less than 2 years ago, creditors still have the right to be notified, and that step must be handled properly to avoid future liability. The next step is to prepare the petition for summary administration. This is a sworn document that asks the court to approve distribution of the estate without formal probate. Your petition should include the decedent's name, date of death, and last known address. You should have a statement confirming that the estate qualifies for summary administration and a list of assets and their estimated value. You need a statement that all creditors have been paid, notified, or that claims are barred. And you may need to publish a notice to creditors in a local newspaper. You'll also need to include a proposed plan of distribution and get the consent of all the beneficiaries in writing. This is usually done by having them sign waivers or joining in the petition. If there is a will, you'll need to either deposit it with the clerk prior to filing your petition or attach the original will and any self-proving affidavits to the petition and file it in person. If the will isn't self-proved, you may need an affidavit from the attested witnesses. Make sure your petition is notarized or verified, and if you're not the only beneficiary, you need to collect signed consent forms from everyone else. Once your petition and supporting documents are complete, file them with the probate division of the clerk of court in the Florida county where the decedent resided or where the decedent's property is located. Keep in mind, the clerk of courts are not permitted to give you legal advice. So if you ask them something and they can't answer it for you, it's not because they're being mean, it's because they're not allowed to give you legal advice. So when you go to file in person with the clerk or use an electronic filing system approved by the county where the petition will be filed. You will need to file the petition for summary administration, a certified copy of the death certificate. You'll need to deposit the original will, and you'll need to file any waivers or consents from the beneficiaries. You'll also need to provide the court with a proposed order of summary administration that you hope the judge will sign. And you also need to keep in mind that each county might have its own required local forms. Many counties require a checklist. You'll need to check the clerk of court's website to make sure that you have everything that is specific to that county. The filing fee usually ranges between $345 and $400, depending on the county, and some counties allow electronic filing, while others require paper filings or in-person delivery. Again, check with the clerk's website or call the probate division for the specifics. If the decedent passed away less than 2 years ago, Florida law requires that you notify the creditors. One way this can be done is by publishing a notice to creditors in a local newspaper that's been approved by the court. You'll also need to file a proof of publication with the court after the notice runs for 2 consecutive weeks, if that's the method you choose to notify the creditors. If the person died more than 2 years ago, this step is not necessary because creditor claims are barred after 2 years under Florida law. Once everything is filed, the court will review your petition. If everything is in order, the judge will sign an order of summary administration. The order of summary administration formally recognizes the will and admits it to probate, approves the plan of distribution, and authorizes you to transfer the assets to the named beneficiaries. This court order is what you'll use to collect bank funds, transfer title to property, and to close the decedent's accounts. Be patient. Some courts process these within a couple of weeks, while others may take longer depending on their caseload. Here are a few quick tips to help your petition succeed. Double check that you're listing only probatable assets. Don't forget to get written consent from all the heirs or beneficiaries. Don't forget to deal with creditors if it's been less than 2 years. And don't forget to use your county's preferred forms. Each court may have slight differences. If you're distributing real estate, include a full legal description and be very careful with the homestead rules. That's it. Summary administration can be a DIY option if you're organized, patient, and the estate qualifies. But if you get stuck or just want a professional to handle it, our office offers flat fee probate services throughout Florida. You can visit us at costpluslegal.com or check out the other videos on our probate resources page. You can always give me a call at 239-220-3100. Thanks for watching.